Okay, good morning everybody. Thank you very much for joining us on what is an absolutely gorgeous sunny day, and I'm sure you must have more interesting things to do than listen to us talking about homelessness in this pandemic situation. Of course, the pandemic at the moment is perhaps ebbing away a little bit, but we're all looking forward to the pubs opening on the 4th of July. It may come back, we may have a second wave, but we thought we'd share with you at this time some of the thoughts that we've had about homelessness in this time of pandemic. So thank you very much for joining us today. I'm Catherine Rowlands. With me are Andrew Lane and Tara O'Leary, and we're from the Cornerstone Housing and Public Law teams. So what we're going to cover in this programme today, we've only got an hour, is investigations under the circumstances that we're in at the moment. And Tara's going to talk to you about the Rough Sleeper initiative and of course bring you up to date with today's news on that and priority need. And then Andrew's going to talk to you about the general duties to people who are homeless or threatened with homelessness, including their prevention and relief duties and suitability of accommodation. We're going to finish off with a Q&A session, as you can see. Now, we've already had some fabulous questions in from you, and we're going to try and cover as many of those as we can in the course of the presentation. Some of them are a bit fact-specific, so we may not get to those particularly fact-specific ones, but if you want to talk to us afterwards, outside the seminar, please feel free to send us an email, give us a call, or send us a brief if you think it's that important. But there is, at the top of the screen, a Q&A button for you to click on. Nobody's sent us any questions yet, but feel free to do so. And we'll try and answer any of those at the end of the session. So, Kate, you're asking, can we see you? No, can't see you, but we know you're there because you're asking us questions. So thank you very much for coming on. It's lovely to have you with us. Right, so without any further ado, I'm going to move on to my section, which is all about investigations. Obviously, the ordinary rule in investigations is it's up to the local authority to be satisfied that it's made all the investigations it has to make. It has to be able to verify that the applicant is homeless, is in priority need, is eligible for assistance, and is not intentionally homeless. Some of those issues are short and sweet, some of them are much more complicated, very much fact-specific, varies on the facts of each case. It is for the local authority to be satisfied, so the inquiries made must be sufficient to satisfy the local authority. What starts off the duty to make inquiries is simply that the local authority has reason to believe that the applicant is homeless or threatened with homelessness. That's a low hurdle. Not much need be said to make you have reason to believe that the applicant is homeless or threatened with homelessness. In a case that I did about 100 years ago now, away from Birmingham City Council, also known as Arley and Birmingham City Council, Mr. Justice Collins at first instance said to us, if someone comes to you and says that they're homeless, in most cases, that's going to be enough. Of course, there are some cases where it's not quite that clear cut, and there are some inquiries that may need to be made, but reason to believe is a very low hurdle, and you should find it very easy to be satisfied that someone is homeless or threatened with homelessness at that low level. You then go on to make inquiries. Those inquiries should be carried out sympathetically. Local authority has to bear in mind that there's no onus on the applicant to prove their case. It's not up to the applicant to prove that they're homeless, in priority need, etc., etc. But nor is there any onus on the local authority to prove the opposite, that they're not in priority need. It's an investigative procedure, not a combative, not an adversarial procedure. It's a local authority carrying out investigative functions. So the reason to believe is a low hurdle. As you will no doubt be aware, under section 213B of the Housing Act 1996, as amended by the 2017 Act, new notification duties placed on various bodies and authorities, prisons, for example, when they're releasing somebody. They notify the local authority that a person is homeless or threatened with homelessness, that they're worried about the person. Does that actually trigger the duty to inquire? The guidance says it doesn't. I'm sceptical about that, frankly, because to me, being told that there's somebody in your area threatened with homelessness or homeless is probably, in my view, enough to get you above that low hurdle. So where there is enough information given to the local authority to let them know that there is somebody who may be homeless, they reason to believe, that may indeed trigger the duty to make investigations into a case of homelessness. It's going to be something that you assess on a fact-specific basis, on a case-by-case basis. It's particularly cogent at the moment, it seems to me. Tara's going to be talking to you about the Rough Sleepers initiative. But where somebody is coming to you as a rough sleeper brought off the street, this may be the first contact we've had with them. It may not be the first contact, it may be a renewed contact. But is there enough in the case that you've got before you to trigger the duty to make inquiries into them as a potentially homeless person? And I would recommend to any local authority that they would be slow to say there is no such duty, because it is a low hurdle, and the fact that somebody is saying that they're homeless, generally speaking, triggers that duty. Coronavirus has made various things more difficult, and in particular, face-to-face meeting. Obviously, here we are today, we're having this seminar by a remote link. It's pretty much standard these days that you talk to people remotely rather than meeting face-to-face. It is possible to take an application from a homeless applicant without meeting them. You don't have to meet them face-to-face. They don't have to fill in any particular form. Lots of people these days have access to the internet. What was it on the news today? We're spending a third of our days online. So certainly seems like that to me. So local authorities having forms online should be able to respond to applications from people in that way. First contact may be a telephone call, and taking information from people over the phone and by remote access, remote Zoom or Skype or whatever it may be, is something that should be done as standard at the moment. A letter. Remember letters? Putting them in the post. We get those by email. Applications do not have to be in any particular format for the investigations to start. But after that, what investigations are you going to need to make? Because not only have you got to inquire into their homelessness, you've got to make an assessment of their circumstances in order to do a personal plan and meet their individual requirements. So whether an interview is needed, whether a face-to-face interview or a Zoom interview or whatever, is a matter for the local authority. In 99 cases out of 100, it would be almost inevitable that there will be one. Sometimes it's going to be appropriate to interview people remotely. And of course, as I indicated at the outset, the pandemic is now declining, fingers crossed. We may have local hotspots, we may have local lockdowns in future, who knows? And so it'll be a question of the local authority making a decision as to what's appropriate in that particular area and in relation to that particular person. Because is the person that you're dealing with someone who's particularly vulnerable? Are they shielding? People are still going to be shielding until at least the 1st of August, possibly longer. And what stage is your organisation at? Whether you're representing the applicant as a vulnerable person, whether you're the local authority interviewing them, what facilities have you got? What arrangements have you made for meeting people, for making sure that they are protected? Perspex screens, hand sanitisers, although, goodness, hand sanitisers are not as good as actually washing your hands, but people seem to think that that's a panacea for all ills. supplying masks to people who may not have access to masks, for example. When you're interviewing people by Skype or Zoom or whatever, obviously they need a couple of things. They need technology. That could be a PC, could be a phone, could be somebody else's PC or phone. How is the person that you're dealing with going to get to the technology in order to talk to you? Could a solicitor lend them a space in their office? Could a charity lend them a technology outlet in some way? Libraries, of course, closed at the moment. When they reopen, that's going to be something that's more appropriate to deal with. And sometimes it's not a question of whether A has got the technology, but do they know which buttons to press? How they're going to actually use it? Not everybody is as tech savvy as your average 4-year-old, but people may be assisted to do that. And again, the roles of charities and social services, again, should not be underestimated here. The same applies to interviewing people by phone. Do they actually have a phone? Can A speak clearly enough down the phone? And that's not just a question of whether they speak the language, but it's an ability to express themselves by phone. When you're face to face with somebody, it is so much easier to make contact because you can say stop, and you can indicate stop by holding up a hand. You can't do that down the phone. So you have to think about things like how their body language and how your body language translates across into a face-to-face or phone, telephone conversation. How are you physically going to get documents? You're going to ask the applicant to provide passports or birth certificates or printouts or whatever. How are you going to do that safely? How are you going to make sure that they're not COVID impregnated? Because that could happen. What are your arrangements for that? This is something that every solicitor's office has got to be thinking about at the moment, every local authority got to be thinking about. Court of Protection have been dealing with this kind of issue. The Court of Protection deals with people who are vulnerable as a standard thing, so they've been giving a lot of thought to it. And they have given a very clear direction that remote interviews for things like capacity and best interests are entirely acceptable. It's acceptable to the Court of Protection, it's going to be acceptable for local authorities making homelessness decisions. But you do have to make sure that the safeguards are there. So it's assessing the ability of the applicant to participate. And this may mean more planning in advance, not just rock up on the day and think, well, how am I going to do this? Planning in advance, what questions you're going to ask. And one thing that we have learned, isn't it, over the last 3 months is how tiring Zoom is. I mean, this is why we keep our webinars to an hour, because it is tiring to do it over such a long period, giving people breaks, making sure that you're going over the ground thoroughly, taking it in short segments. Public sector equality duty is, in my mind, something that is going to be absolutely key, and inquiries into this are going to be really key at this stage, because mental health issues, we have all been feeling anxious, overwhelmed by the situation, under pressure, under stress, cut off, lonely. Those kinds of feelings, when you have mental health problems that maybe were dormant or incipient before the pandemic, may have been brought to the fore now, may have been exacerbated or even caused. And so you may be dealing with people who have got genuine mental health issues, who did not have them before the pandemic or did not have them recorded before the pandemic because they weren't able, they weren't needing to access a GP and haven't been able to access a GP during the pandemic period. So the one thing that the public sector equality duty engages, in my view, is this: do not wait for A to self-report. Do not assume that because they haven't had mental health problems before, they haven't got them now. They're not vulnerable because they weren't vulnerable 12 months ago or 3 months ago. And this may be relevant to a lot of issues. Intentionality. Taking a bad decision because of the stress of the pandemic, because you're under the stress, maybe being furloughed suddenly, things are coming out of the woodwork that never affected you before, and it may relate to that kind of transient, possibly, anxiety, stress. This is something that a local authority is going to have to deal with sympathetically. And of course, it's going to be relevant to priority need. Is someone who has got mental health problems particularly vulnerable during the pandemic period to the stress of being homeless, particularly at a time when a lot of the usual support mechanisms have been cut off? So you've not got the charities with open doors, you've not got libraries with the PCs that they can use to get help. And of course, GPs at the moment, they've got all their problems. They are also overrun. Sometimes GPs are failing to respond either to the applicant asking for assistance or to the local authority asking for information. And I have been asked, well, I can't get anything from the GP. Does that mean to say I could go without it? No, you have to keep passing on. You have to keep pressing the GP. Maybe you need to refer to somebody in social services to get either information that they can access or to get an opinion as to the mental health problem, because a social worker can give you input as to that. This may be the first time applicants come to you, not just for help, but for other services as well. And so, of course, issues arising out of coronavirus include the financial consequence of this, furlough, redundancy, all these sorts of things. And one thing that strikes me is that there may be lots of Haley and Waltham Forest, if you pronounce it Haley, I don't know, issues coming up. Somebody who was intentionally homeless would have been made homeless anyway because of the consequences of the pandemic. And bear in mind, landlords are also going to be feeling stressed and also going to be feeling uncertain in this time of pandemic. And so there is a lot to be said for working with landlords to try and prevent homelessness, bearing in mind your knowledge of the current situation in your area. Okay, I'm going to pass on now to Tara. She's going to deal with the Rough Sleeper initiative to start off with and bring you up to date on that one.
Thanks very much, Catherine. That's really, you've covered some points that are relevant to what I'm going to say, so that's very helpful. Good morning, everyone. I hope some of you have taken the very sensible decision to watch today's webinar outside in your garden or patio. I certainly wish I was giving it outside in the sunshine, but I don't think I have the technology for that. So we know from a lot of the questions that came into us in advance that quite a lot of the participants today are really interested in rough sleeper initiatives, and in particular in how local authorities can assist those who are ineligible for support. And so I'm going to focus a little bit on that and try, although we can't answer some of the very fact-specific questions that were sent in to us, to try and give some broad advice as best we can. So I've just given you here a quick chronology of basically what the government has done to date. Just to point out that the starting point in all of this is that the current government already had policy on a rough sleeping initiative, and there was a earmarked funding over the course of 4 or 5 years. So the budget at the start of this year was allocating 112 billion. I think in terms of a lot of the subsequent budget announcements that have been made in the course of the emergency, it's probably fair to say that a lot of that 112 billion and maybe some of next year's funding has been diverted elsewhere. So whilst there is to some extent a magic money tree which has appeared in recent weeks, and that's no bad thing, at the same time it may be that there is a longer term impact in terms of what would otherwise happen to help rough sleepers potentially may not now happen because the money has been diverted. So around the 26th of March, which was 2 days after the commencement of lockdown, basically the government just asked local authorities everywhere to get everyone off the streets as quickly as possible, and that's been known ever since as the Everyone In initiative. Statistics put forward by the ministry suggest that genuinely tremendous efforts have been made, and I think a lot of credit is due to all those involved. Initially, the ministry said 5,400 rough sleepers had been accommodated safely, which means in individual hotel rooms rather than in crowded dormitories. And apparently that represented 90% of those known to local authorities at the start of the outbreak. To me, when I read that, raised the obvious question as to what happened to those who weren't known to local authorities. Unfortunately, my experience living in central London, having taken some walks around the West End when things were very quiet in April and May, was that it was clear large numbers of people were still out and about, neutral elsewhere and so on, and a lot of them were very vulnerable and probably not involved in social services. More recently, including this morning, there's been references to 15,000 people being accommodated. So I don't know whether that situation has improved, or whether in fact some people who were initially in accommodation have now gone back out into the streets again. I think it's a little bit unclear. In any event, on the 2nd of May, there was the announcement of a creation task force. And I think, as you'll see in a minute, some of their recommendations might be starting to filter through. 24th of May, announcement of funding, basically to try and actually get homes to provide longer term solutions to rough sleepers. Catherine, if we can just move on to the next slide. Earlier this morning, the government made a new announcement, which is an allocation of an extra £105 million in broad terms to extend the Everyone In initiative up until the end of this financial year. So that's quite big news. I was frantically drafting a new slide about half an hour ago to stick in here, and I haven't had really a chance to explore this announcement, but I've copied there from the government press release what is said about what the funding should be for. In my view, I think the likelihood is that there's going to need to be a move away from night-by-night hotel accommodation into something longer term. The suggestion has been given for student dorms and accommodation, which are not being used by universities at the moment because students are studying from home. But it may be that other PRS rented flats and so on will also be available. And I think the clear steer here is to be as creative as possible. Also, the fact that possession proceeding will recommence in August might mean at a certain point in the autumn we'll start to see a little bit more housing stock become available. But that's certainly one to watch, and I think that probably seems to be an outcome of a lot of lobbying that's been happening in recent weeks. Next slide, Catherine. I think there's some clear problems with what's been happening so far. Some of this, this was a slide I drafted before the announcement this morning, and it may have been overtaken by events to some extent. But, you know, a lot of people will have seen Inside Housing report on the ministerial letter sent out on the 28th of May, which included, you know, a suggestion that rough sleepers should now be moved on from their hotel accommodation, and included just a frankly really unhelpful list of suggestions, such as returning to family and friends. In other words, can you please stop being homeless? Or offering migrants voluntary return to their countries of origin, which is particularly ironic in circumstances where the airport is hardly open at the moment. But in any event, the key problem, which I'm going to move on to addressing, is the fact that the Housing Minister suggested there's no planned legislative reform on a temporary basis or otherwise regarding households who are ineligible for support, or more broadly, no access to public funds in terms of social welfare. And you can see a list of charities around the start of June estimated shockingly that in some parts of England, some clusters, up to 50% of the sleepers might fall into that category. So for those who are eligible, to start with, here are your powers for how you can accommodate them. I suspect nothing here will be a surprise to anyone, but firstly, as Catherine's just addressed, when someone gets over the low threshold of there being reason to believe they are eligible, in priority need and homeless, then you have the Section 188 accommodation duty. For persons who are eligible and who are already homeless, regardless of priority need, the relief duty applies. The relief duty, of course, for securing accommodation for up to 6 months. So certainly giving them referrals, advice and assistance into the private sector would be permitted there, but potentially also if local authorities were to place them directly into something slightly longer term than that hotel accommodation with a 6-month license. And then finally, of course, if families' main housing duty has been accepted, you've got the temporary accommodation duty. Now, moving on to ineligible applicants, I'm going to focus a little bit more on this because I think it's more difficult. Most of you online will know very well those who are ineligible are those who are assessed as being excluded from access to the Housing Act Part 7 and social welfare more generally in consequence of their immigration status. What I've done is I've identified about 8 different statutory powers, which in my view, and only my view, you can use to assist ineligible rough sleepers or homeless persons. It's probably fair to say that the quality of these statutory duties varies quite a lot in terms of what it permits local authorities to do. But I'll run through them. The first is the issue that the duty to provide interim accommodation. Apologies, I've just had a notice from my computer saying my audio quality is low, so my apologies if anyone has difficulty hearing me. Catherine's already talked in some detail about the low hurdle for someone to fit within this category of being given interim accommodation under Section 188. All I will say is that, in my view, that also applies to their eligibility status. And if there is reason to believe they may be eligible with that low threshold, as highlighted in code guidance, and I've given you the case of Ken there as well, then you can provide them with interim accommodation. That would almost certainly apply to anyone whose immigration status is unclear. Arguably, perhaps someone who's got an appeal pending, an immigration appeal pending, and so that would get them in the door of interim accommodation. Secondly, there is of course also a discretionary power to extend someone's interim accommodation, even if you have determined that they are not eligible, because they have Section 202 review option on the eligibility decision, and you could decide to continue their interim accommodation whilst that is pending. I should say under paragraph 1, there's no time limit on a Section 184 decision, so I suspect quite a lot of local authorities in practice during the sort of height of the emergency will have been quite happy perhaps to delay that decision to some extent. But obviously points 1 and 2 here can't go on indefinitely, and over the next few months local authorities are probably going to have to reach decisions on those fronts. Number 3 goes hand in hand with 1 and 2 to the extent that even if you decide that they're not eligible and that you're going to have to terminate their interim accommodation, there is a relatively open-ended discretion to extend the notice period for as long as the local authority thinks reasonable, quoted from code guidance, taking account of their needs and the time that they would need to arrange alternative accommodation. So whereas normally you might give a 14 or 28 day notice period, that's something that could be extended at the moment. Going on to the next slide, number 4 is the bottom tier, lowest rung of the ladder duty, which is owed to every homeless person in England, and I assume in Wales as well, which is regardless of immigration status, there's a duty to provide information and advice about accessing housing. Now, I'd recommend anyone here looks at paragraphs 3.2 and 3.7 of the code guidance. They refer to essentially saying that information and advice can include, firstly, referrals to third-party charities who might work with ineligible persons, but also that information and advice can include how to obtain accommodation in the private sector. So, and in fact, under Section 1793, local authorities have power to provide funding to organisations who work with ineligible persons. So I think that's a very broad and permissive power, which would certainly help, would permit local authorities to effectively simply just place ineligible persons into the PRS if they chose to do so. A brief reminder at point 5 about a power that certainly as a barrister I don't hear about very often in practice, but there is a limited homelessness duty to households which include restricted cases. Restricted cases are those with a somewhat unusual set of facts, which is that the homeless applicant who approaches the local authority themselves is eligible, presumably because they will have either a British passport or right to remain. But their only link to priority need arises from someone else in their household who is not eligible. So the factual scenario might be a child who's aged over 16, has a British passport, and has a vulnerable parent or older relative who lives in the household with them, but who themselves is not eligible. And in those circumstances, the main housing duty can be accepted, but can only be discharged by way of a PRS offer rather than Part 6 offer. So that's something that potentially might come up in some of the cases. And now, moving on to duties which arise outside the scope of the 1996 Act, Section 17 of the Children Act, if you have families with no recourse to public funds, but there are children who have been assessed in need by children's services, that can include provision of accommodation, and I've given you a reference to some of the main case law on that there. The next slide is similarly adults who have care and support needs and have been assessed as having care and support needs under the Care Act 2014. I would treat this one with a lot more caution than the Children Act, to the extent that there is a decision which says that if the care and support cannot otherwise be provided without giving them accommodation, adult social care can step in and provide housing, but there's some conflicting decisions about that, and in practice that's extremely rare, and certainly your adult social services teams are not going to want to well, they're not going to be very receptive to the suggestion they should step in and provide homelessness services. So I think all I would say about number 6 and 7, Children Act and Care Act, is that the key issue is that other social services agencies need to have assessed that there are additional duties owed to the homeless persons. Accommodation really just piggybacks off the back of that. And that brings us very briefly, and I'm trying to stick to time because I know I'm running over a little bit, to the general powers of competence under the Localism Act. We had a couple of questions about this specifically in advance of today. The bottom line with the Localism Act is that case law says it only empowers local authorities to take steps which are not prohibited by other legislation. And the main authority I've identified on this is a case KM from 2013, where the High Court held that Section 1 did not allow a local authority to provide accommodation to an overstayer, so someone who was ineligible, precisely because she was a person who had been specifically excluded from assistance under the 96 Act as well as some of the immigration acts, and was saying that using the Localism Act in that way would just simply circumvent what Parliament had decided. Now, I think there's a few things to say about that, one of which is that was actually just a first instance decision from High Court, but it's not been appealed, and there's certainly very different facts pertaining at the moment under the circumstances of the pandemic. I think it's also probably fair to say that a local authority is very unlikely to be challenged if it decided to rely on Section 1 of the Localism Act in order to provide accommodation. But there might be more difficult questions arising as to when it decided to discharge or stop providing that accommodation in due course. List of useful resources, it's there for your reference. All I'm going to say is very briefly on priority need, that I have provided the main categories there that I think are relevant to people who might come across during the pandemic. Vulnerability is the obvious one, but also to remind you that there is a priority need category which arises in the event of emergency, theoretically might apply to someone who has had to leave their existing accommodation in order to shield or because they have family members shielding. And number 3, of course, we've heard lots of grim statistics about the increased prevalence of domestic violence at the moment, and that might arise as a direct consequence of the pandemic. On the next slide, I've set out the tests, but I'm not going to run you through them. All I will say on priority need is you still have to make the usual decision you always have to make, which is this person more vulnerable than an ordinary person when made homeless, in consequence of probably their health conditions and the context of coronavirus. So you're still entitled to request evidence from a medical practitioner that they are in a vulnerable category if they say that they need to get off the streets because they're at higher risk of harm if they catch the virus. And you're also entitled to take into account support that might be available to them, such as family members letting them stay over. But I think if there is somebody who can clearly show that they are at much higher risk than an ordinary person in consequence of them having some sort of underlying health condition, which means the consequences of coronavirus could be very, very serious for them, I think you would need to think quite carefully as to whether or not they meet that test. And I know there will be loads more questions on both of those topics, but please do feel free to follow up afterwards.
Thank you very much, Tara, and thank you, Catherine, as well, for the introduction and the inquiry section. I'm going to be looking over a few slides on the question of homelessness duties more generally, and hopefully we'll have plenty of time at the end for questions which Catherine will coordinate. In terms of the impacts of COVID-19, that's already been addressed to a certain extent, but I've identified certainly 6. There's a lot of people who are unable to stay or have been unable to stay in accommodation where they had been previously accommodated because it's no longer suitable because of the risk of contamination, etc. And I've certainly had cases where somebody wants to leave or has been required to leave because of that fact. People obviously are having difficulty paying rent and mortgage if they're being furloughed or if they're self-employed and their earnings have reduced, or if of course they've been made redundant. That's clearly going to have an impact, and of course is the motivator for the whole question of the possession stay, which has now gone up to the 23rd of August. Until recently, there were problems with people not being able to move into accommodation. That's been slightly overcome now because that is now possible. Clearly, there's been accommodation which is not suitable, and local authorities have been working very hard in ensuring that particularly those facilities with shared accommodation are very carefully dealt with when it comes again to the possibilities of contamination. We've also heard, of course, more generally in the news about domestic abuse and the increase, regrettably, in those instances. And of course, we've also heard about the Domestic Abuse Bill, 2019 to 21, which is going to make it much easier. I'm sure we'd all agree it's a good move for those suffering domestic abuse to be housed without having to prove that they are vulnerable. And of course, as I've already indicated, there's been issues to do with the question of the 3 months notice being served, and we'll see later that there's an impact on that when it comes to threatened with homelessness, because landlords now, whether it's a local authority or whether it's a private landlord or a housing association, are going to have to give no longer 2 months notice, for example, for Section 21 if you're a private landlord or housing association, but 3 months, and the same for notices seeking possession and notices to quit. Sorry, not for notices to quit, but for notices seeking possession. And so those are the impacts. Though equally, I ought to add one, which is just very briefly, of course, that local authorities have had to be reorganising their staff as well because of the problems, and some of the staff being furloughed and some of the staff being reallocated to different departments. And so that's clearly had an impact. And looking more particularly at the duties that are impacted by the virus, we've had, of course, the section that Catherine's dealt with on inquiries. I should just say, in relation to that, there was a question by Chris as to the fact that an application would need to be made before the duty is triggered. Well, that's obviously right, but I would just advise that the application doesn't have to be in a formal application form. And indeed, if you have a look as an example, the Code of Guidance 18.5 to 18.7, it will give a number of examples, such as, for example, somebody inquiring about the Part 6 allocation scheme may be treated as an application for homelessness. And it actually says this should be regarded as an application for homelessness assistance. So one shouldn't be looking for formal application forms. It could be a much less than that. I should also say, before looking at these items quickly, Kate quite properly raised the Hale, and that's how I pronounce it, the Hale and Moreton Forest case and the intervening act. And of course, that will be very relevant. I mean, in Hale, we had the problem of somebody who was pregnant and therefore wouldn't have been able to stay in the accommodation anyway. And of course, with the coronavirus, there may be people who were intentionally homeless, but wouldn't have been able to stay where they had been staying because of the risk of infection between households. So yes, that's certainly an issue that will come up. I've also incidentally been told from the questions, I think it was a comment rather than a question, that one local authority was going to be allowing those intentionally homeless, to whom, of course, if they have priority needs, the duty is only to house so long as it's necessary to enable the person to have a reasonable opportunity to find their own accommodation. They're certainly going to allow those to stay until the 23rd of August. But I'm going to be looking more particularly at the assessment duty under 189A, the prevention duty at 195, the relief duty at 189B, and briefly I'll reference the accommodation duties and powers that we have seen. So homelessness and threatened with homelessness. Well, none of the legislation, of course, has changed by the coronavirus. We've had, of course, the Coronavirus Act, and we've had Section 81, and we've had Schedule 29, which has impacted upon possession claims. And we've had other legislation which is within that, which has talked about commercial premises. But in terms of homelessness, the Act is the same. And therefore, in that sense, it's no different. And of course, the Code of Guidance hasn't changed either. There have been particular guidance, as Tara has gone through, in relation to rough sleepers, but the legislation is the same. And I've just highlighted subparagraph 5 of Section 175, which is the start of Part 7 of the Housing Act 1996, which of course deals with the question of threatened with homelessness. Because what the intention behind this was to stop local authorities not doing anything until somebody had a date of eviction. In other words, if they've got a Section 21 notice, they should be starting the process of assistance if they qualify for assistance or if they're eligible. and if they're homeless or threatened with homelessness, you should be starting off with the prevention duty. And there was a question that was raised about, well, is that impacted, of course, by the 3-month changes to the notices? Well, as I say, the legislation hasn't changed. And so if somebody has a 3-month Section 21 notice issued in March, April, May or June, then of course, if there's less than 56 days to go, the local authorities should be put on notice they need to do something. More obviously, of course, duty. So they'll be put on notice at that stage. That hasn't changed. And that's equally the case, incidentally, when it comes to saying, well, look, even if the notice is within 56 days of ending, they're not going to be able to get evicted because, of course, possession claims, although they can be issued, they are stayed until after at least the 23rd of August. Well, again, that may impact upon the quality of the prevention duty, but it's not going to impact upon the question of whether the individual is threatened with homelessness. If we have a look at the next slide, please, we have a look at the prevention duty. And the prevention duty is fairly clear as to what it entails. Must take reasonable steps to help the applicant to secure that accommodation does not cease to be available for the applicant's occupation. Well, subject, of course, to it remaining to be otherwise suitable. That's slightly easier at the moment because, as I say, unless a landlord acts unlawfully, they can't actually evict. And therefore, it's not going to be too difficult to stop them not having that accommodation. Although, of course, this prevention duty does require a housing needs assessment under 189A and a personalised housing plan to look to the future, of course, when the stay will be lifted. So there may be work in any event that needs to go on with that. And one can see that when we look at the next slide, which is the Code of Guidance. And Catherine has dealt with the question of the difficulties about these. This guidance wasn't done with a view to the coronavirus outbreak, but of course it did anticipate that it wasn't always going to be possible to do a face-to-face interview. Now, there has been very little in the way of challenge to housing needs assessments. And remember that housing needs assessments were there long before the Homelessness Reduction Act of 2017 amended the 96 Act and introduced the prevention duty. It was there, for example, when one was looking at intentionality and needing to do an assessment. And again, it was rarely challenged. I have a challenge at the moment in the administrative court, both to the allocation scheme and indeed to the failure to do a proper housing needs assessment. And it is something that, of course, needs to be properly done, although, as Catherine has said, it's not going to be that easy to do it in as clear a fashion as perhaps was the case previously, although hopefully over time that will get better. If we have a look at the next slide, we look at the relief duty. Well, of course, this is a question which arises not when they're threatened with homelessness, but when the applicant is actually homeless and eligible. And there is a question that's been raised about what's the impact on the relief duty, given that there can't be, it's not going to be easy to do inquiries within what was said to be the 56 days. The only stress I would put about the relief duty, it's of course not a duty to provide accommodation, it's a duty to provide help to an individual to secure accommodation. It may be that the local authority provides accommodation, but that's not the requirement under the relief duty. But equally, it's got to be done properly. There's got to be a proper housing needs assessment. There's got to be a proper personalised housing plan. And if that is the case, then it's something that clearly has to be addressed properly. And it may well be that the relief duty at the moment is taking longer than the 56 days. And of course, you'll be well aware, I'm sure, that the relief duty itself isn't a 56-day limit. The 56 days is just one of the bases upon which you can end the relief duty. You don't have to, and I've got cases, and I'm sure you've had cases, and I'm sure Tara and Catherine have had cases where the relief duty has gone on, in one case I've got, for well over 4 months. So it doesn't have to end on 56 days anyway, but clearly it's impacted by the coronavirus because of the difficulties initially of actually securing accommodation, because applicants couldn't move into any accommodation even if they identified it, but also the difficulties of actually getting a proper housing needs assessment and a proper personalised housing plan and a proper series of assistance steps put in that plan. Now, I've done a slide on the Code of Guidance, which hopefully is self-explanatory, and it just says the duty applies when the housing authority satisfies the applicant is both homeless and ineligible. The housing authority is obliged to take reasonable steps to help the applicant secure accommodation with a reasonable prospect that will be available for the occupation for at least 6 months. That's the relief duty guidance reference. And of course, they're referring then to the interim accommodation at section 1881. And we'll see shortly and briefly, there is reference to the suitability of such accommodation. Now, I've also put at the end a case of Mitchell and Islington, which some of you may have read, which, if it's possible with our wonderful technology, I'm going to transfer quickly. I'm going to transfer. Catherine hopefully will come in at this point to explain, because it was her case, what Mitchell and Islington was actually about. So, Catherine, if you can hear me, are you able to come in and explain that case?
I can. Well, this is really a very... Oops.
Yeah.
Yeah.
Volume's on now. Yeah, that's fine.
Right, you can hear me.
Yeah.
Yeah. Okay. Very quick case about ending the duty when it comes to section 1881 temporary accommodation. It's not sufficient to say that you are satisfied that the applicant is not in priority need, having completed your investigations. With Mr. Mitchell, Islington thought that he probably was in priority need at the reason to believe stage. Having completed their investigations, they thought they were sure he wasn't. But that's not enough. He had to have all the boxes ticked and notified that the section 189 to B duty had would not be owed to him. And it had to be spelled out in terms, not just in terms of saying you're not in priority need, but in terms of saying the duties under section 190 will not be owed to you when the relief duty comes to an end. It's an uncomfortable decision because it left Mr. Mitchell no better off than he was when he started. He's still not accommodated by Islington despite the litigation. But what we did do was dismiss the argument on behalf of the applicant that the section 1881 duty itself couldn't come to an end until the relief duty had come to an end, which is what was being argued. Right, I'll hand back to you, Andrew.
Excellent. Thank you very much, Catherine. I'm going on to my last two slides. Suitability, it's there. Hopefully it's fairly clear. For some people, they need self-contained accommodation. That's clearly going to have an impact upon where you place people, whether that's temporary, interim, out of borough, etc. That's clearly affected. Of course, that's been assisted by the slight prevention of any restrictions in moving, which of course there had been initially, which was causing tremendous problems, and had originally talked about no moves happening and no viewings happening. What I would say in terms of cases, because one might have expected a few cases on this, there have been some, and just to very quickly mention the case of Escott and Chichester. Escott and Chichester District Council was just a case for an interim relief application. The court there refused to order a local authority to provide furniture and white goods in an unfurnished self-contained accommodation which had been provided to a homeless individual during the coronavirus pandemic. And Mr. Justice Martin Spencer said that the local authority faced many competing demands due to the pandemic, and it had not acted unlawfully in providing a cooker, fridge and bed so that the individual, not providing a cooker, fridge and bed so that the individual could more easily self-isolate in the flat. They had, in fact, I should stress, tried to provide assistance, but that wasn't always taken up. And there was, secondly, a case of TAMO and Lambeth, London Borough Council, which was an application for enforcement of an order requiring a local authority to provide a claim for suitable accommodation under section 188 was adjourned, where the reason for her not applying for housing benefit was obscure and required further information. There had been an order that accommodation be provided, and that hadn't happened. But the question of that was adjourned to see whether the applicant was cooperating with the case. And my final slide, really, and it's nothing to do with the pandemic per se, but just really reminds people of two cases. There's lots of cases on suitability. There's lots of cases on the fact that, of course, something may be suitable in the short term, may not be suitable in the long term. And you can see on these cases, of course, Cannon and Newham and Haruki and RBKC, some of those issues. So in other words, you've got something like Haruki, who hopefully were going to be rehoused in good quality accommodation, but in the meantime, there was no reason why they couldn't stay where they were, even if there were obviously issues which meant that the property wasn't ideal. And similarly, in Cannon and Newham, a local authority's review of its decision that accommodation provided to a disabled person was suitable was vitiated by flaws in the review officer's assessment. The officer had failed to consider the accommodation which might be suitable in the short term, and of course there's plenty of authorities on that, might become unsuitable with the passage of time, and of course the public sector equality duty. Now, as I said right at the start, the pandemic will have an impact upon the suitability of accommodation both ways, both in terms, for example, of self-containment, but also in terms of the ability and the realistic ability of a local authority to find accommodation, given that a local authority is entitled to consider its resources and more to the point, the housing stock in its area. And therefore that is going to affect it both ways. So that's my bit, and I'm going to pass back now to Catherine, who is going to identify some questions which she can catch us out on.
Well, what I'm going to do first of all is go back a bit to Tara's section, because I know a lot of people had difficulty with, unfortunately, Tara's audio was a bit crackly at the start of it. So I just want to go back to the bit where it was particularly bad, and providing interim accommodation to ineligible applicants, and in particular chucking people out once you wanted to finish accommodating them. And one question has been asked: does the current ban on possession proceedings extend to people who are accommodated under any of these powers? Do they benefit from the court stay at the moment, or can you just ask them to leave and, if necessary, grab them by the scruff of the neck and put them on the street?
Thanks, Catherine. So I'm so sorry to everyone about the audio problems. I hope you can hear me better now. It's really hard to keep an eye on the Q&A function and text messages. I'm sorry that I didn't be aware of that, but I've turned my Wi-Fi on and off again now. I've advised another local authority recently that the stay on proceedings does not apply to Section 188 night by night interim accommodation. Because of course we know from the Lewisham case before the Supreme Court a few years ago that one doesn't need to serve notice of quit or get a court order of possession from Section 188 interim accommodation, at least not unless the license agreement given by the local authority says they'll do that. So you're out, you're not in a situation where you need a possession order, and so therefore obviously the stay doesn't apply to that. That said, I told my client to approach the matter with extreme caution, I think was the phrase I used. There's a very clear policy steer from government and from the public health authorities that people are supposed to be in off the streets at the moment. Secondly, there's very difficult questions to be asked about if you tell someone to leave and they don't leave, what you do in response to that. I would certainly not be suggesting that you send in your burliest, strongest council officers to remove them with force from the premises. And I've reminded them that any decision to terminate interim accommodation can be amenable to claims in judicial review and applications for interim relief or injunctions, which would require accommodation to be provided. So all of those things mean, I think, unfortunately, they do need to be very careful. In circumstances where somebody might be causing terrible antisocial behaviour in interim accommodation, the situation may be very difficult and complicated. But it may be that you deal with it by moving a person elsewhere, which you can usually do more or less overnight. And it may also be that if a decision is taken to terminate, somebody is given reasonable notice of the termination, efforts to help them find or arrange alternative accommodation, which will clearly get easier now that the property rental sector is reopened and more accommodation is available, and give very careful reasons for doing it.
And in terms of the other ineligible routes to accommodation, this was another part where you were a bit crackly. You mentioned in particular the other powers under the Children Act and the Care Act and the Localism Act. Are any of those particularly vulnerable to challenge by applicants against local authorities? Is there anything that you think local authorities out of those should be particularly worried about?
I think those are three areas which all need to be considered very carefully. So both Children Act and Care Act cases, I had been suggesting, and maybe it wasn't coming across on the audio, that they only apply, and then accommodation is only a possibility in circumstances where specialist social care agencies have accepted statutory duties to the applicant or their household, which are not duties under the Housing Act 1996. And it's only if those other duties are engaged that accommodation might potentially piggyback off the back of those duties. So obviously your children's assessments and your Care Act assessments would need to be carried out carefully. Unfortunately, I've given you 3 authorities on the Children Act. So accommodation is actually provided quite often in practice by children's services to families with no recourse to public funds, Zambrano carers, cases like that. The adult social care section is a little bit more complicated. There is a case from, I think, about 2013 or 14, which suggests that if social care would be unable to provide the care and support services that the person needs unless they are also given accommodation, the case suggests that they can be required to accommodate under the Care Act duties. But there are a few subsequent decisions which conflict with that, and it's definitely a point of contention. I think local adult social care services would be horrified by any suggestion that they would become a homelessness agency. And so I think that's one that needs to be done very carefully. The Localism Act, I've highlighted the case of KM because it says that you shouldn't be using the Localism Act to accommodate people who are otherwise excluded from the 1996 Act. But I also said that was the first instance decision. It's from quite a few years ago. It was from a very different set of facts. Possibly it might be distinguishable in the unique circumstances of coronavirus, where things like policy prerogatives, which suggested that illegal overstayers shouldn't be provided benefits here, they no longer apply because people can't go back to their countries of origin even if they want to, and third-party charitable sources of support have closed. So also, a local authority is unlikely to be challenged if they decide to accommodate under Section 1, but would need to handle it very, very carefully when they decide to terminate that assistance or discharge it and try to move the person on, and make sure that they do so by assisting them into alternative accommodation.
And one of the things that I'm sure all 3 of us would say is keep records, make sure any local authority decision is recorded, explain to people the basis upon which they're being accommodated, how long it's likely to last, and what happens if they commit antisocial behaviour, for example. Because one of the questions that's just been asked is this: if you've got somebody who is normally street homeless and rough sleeping, they are provided with accommodation, but you want to terminate that because of antisocial behaviour or whatever else it may be, does that prevent you from doing so? Does that mean that the local authority is bound to accommodate someone regardless of their behaviour? What would your response to that be, Tara?
I don't think that someone can behave as badly as they want to, and you have to continue accommodating them no matter what. But the matter needs to be handled carefully. There needs to be a careful investigation, probably using all the really good hints and tips that have been given by Andy and Catherine today. You need to keep records. I mean, there's a big difference between evicting someone overnight because they're causing antisocial behaviour versus giving them 14 or 28 days notice of that and potentially moving them somewhere else in the hope that they might behave better while that notice period is pending. There's also, if somebody is engaging in serious antisocial behaviour because it's clear that they have mental health problems or substance abuse issues, you're going to need to very carefully consider your PSCD, potentially social services referrals to try and get to the root of the problem. And yeah, I'm not sure there is always an easy solution, but it also doesn't mean that they need to stay there forever. So,
Catherine, can I just raise something while trying to ignore the knock on the door? And that's just, I've been asked a question by Anna about the relief duty, and that it would normally end after 56 days if the person is owed the full duty. And that's absolutely right, of course, because that's what Section 189B subparagraph 4 says.
Yes.
But of course, that only applies where the local authority is satisfied that they have a priority need, which may be fairly obvious if they've got children, for example, or they're satisfied that they became homeless intentionally. In those circumstances, it may be that you're not satisfied they became homeless intentionally, and therefore you can't really deal with it, and you can continue with the relief duty. And that may be because of the inquiries problems that you indicated in your section at the start.
Yes, I mean, the relief duty is in those circumstances replaced by the full duty, so you're not losing anything there as an applicant. But where inquiries can't be completed within the 56-day period, then that is a reason for extending the relief duty.
Absolutely.
And of course, at this particular time, everything takes longer, doesn't it? GPs are slower to respond, social services are overworked, so they can't necessarily help you out. Loads of things can happen. And the relief duty is something that you can extend, and in fact, in the Mitchell case, that was one thing that Islington were very keen to do, was not to terminate the relief duty because he was somebody that they wanted to help, not accommodate, but helped find his own accommodation. Yeah, the relief duty comes to an end in circumstances when either the full duty is accepted, so you're going to help them another way, or you're going to carry on helping them as long as you can. But there does come to a point where you just think we've done everything we can to help you regardless of coronavirus, and then we're going to end the relief duty at that stage. Just one final question's just popped up. If this everyone in means the local authority has to house everyone, what's the point of evicting problem tenants? We'll just be shifting the problem. And not everyone that's evicted ends up on the streets, of course. They do find other accommodation. But you can't just say they're antisocial, we're evicting them, that's the end of it. There have to be thought given to the duties that you owe to children, the duties you owe to people with mental health problems, all those sorts of things. But the request from government to accommodate everyone is, it's not statutory guidance, it's non-statutory guidance, as I understand it. Is that right, Tara? It's non-stat guidance.
I mean, I don't think
Absolutely. I mean, there's no requirement to accommodate everyone. The Rough Sleepers thing was a government letter, I think, on the 25th of March. And obviously local authorities cooperated as quite properly they should do, as far as they could. But there's no requirement. And of course, going forward, and this is one of the questions we had about where we're going to be in 6 months' time or 12 months' time. Of course, there'll be the same system. As I mentioned, the legislation is exactly the same as it was before the pandemic. The emergency measures, quite properly and understandably brought in, will no longer be there. And although, of course, there is hope that the Rough Sleepers issue will be dealt with, and this will be the time to deal with it properly, of course, that won't stop people at times becoming homeless. Although, if they change the Section 21 rules and abolish that, then of course, it may make it more difficult. But so it's not going to be the case that going forward, everyone will have to be housed. The only thing at the moment is that rough sleepers shouldn't be rough sleeping.
Yeah, I'd agree with that. Just to say, there's no, as far as I know, there's no guidance on rough sleeping. It was simply a ministerial letter sent to all local authorities, sort of asking them to make special efforts because of the public health implications. But as Andy says, the sort of dangers and risks of rough sleeping are going to change over time as well as the sort of pandemic hopefully passes us by, and there isn't any changes to law reform. So yeah.
And there was another question I was going to ask. This one, priority need category of emergency. Could this also apply if the applicant loses their job or furloughed due to the pandemic, so they cannot pay their rent and their accommodation is no longer affordable, as benefits do not cover the rent, e.g. Due to a local housing benefit cap, meaning that in effect homeless has no longer reason to continue to occupy. So would you come under the priority needs category in those circumstances? Or is it just a question of whether you are intentionally homeless or not? So, Andy, that one for you, I think.
I mean, I'm not saying it can't be argued. I mean, there's plenty of good lawyers listening to this who probably would argue it. And the examples given in the legislation is fire, flood or other disaster. And you might say that that applies here. It's more obvious, of course, if you've got flooding and your house is completely unusable, or if you've got a fire and therefore you can't obviously live in the property. But it's certainly no reason why you can't ask for it to be treated under that, and you can't look at it being a priority need because of Section 1891D. There's no reason at all. Whether or not that is going to be accepted by the local authority is a moot point, and I think all I would say is that there's been no authoritative guidance or decision on that point. And so, yes, you can ask, but it won't necessarily mean that it will comply with 1891D.
And of course, Andy Gale's made the point, it's not a fire, flood or other disaster. It's not in that context of something that suddenly happens like an earthquake or the house falling down on you, but it is an act of God in that sense. So yeah, it's not quite a justum generis, to use the Latin that we're not supposed to.
No, but it is something where you've had to leave the property quickly, isn't it?
But it may not be. It may not be necessary to consider that, because this is somebody in those circumstances. They're unlikely to be considered to be intentionally homeless. They're probably going to be unintentionally homeless, and may well have children, so they're in priority deed anyway. So it may not come up. I had a couple of questions about prison and the Rough Sleepers initiative. Andy Gale tells us has been extended by some local authorities to people coming out of prison. But other people have asked the question, well, what if you can't actually get access to the prisoner? You've got notification that they're coming out, but you can't get in contact with them. There may be reasons for that. Maybe the person coming out of prison doesn't want to have contact with the local authority. Various reasons of distrust or previous bad experiences or things like that, or they've just got somewhere to go and they can't be bothered. So in those circumstances, there isn't, in my view, a duty on the local authority to go and track them down, but I'd have a file open on them so that you've got something to start off with if they do come back. This is part of the background that you may have to deal with. So there's a difference between having an application open and accepting a duty. I'd open an application if you've got enough to raise the possibility that they've got reason to believe that they're homeless, and I would then leave it dormant for a while until you know what's happening with them. Okay, I now see it's 12:10 and we're beginning to lose participants, and I think we've covered most of the questions that have been asked over time. I hope that's been of use to people. It's the kind of thing where I really wish we could all be in a room together and all share experiences. So please do feel free to contact us with any further issues and talk to us either by email, by picking up the phone to us, or contacting us via our clocks. Oops, I seem to have stopped sharing the screen. And I meant to put up the final slide that gives email addresses, but all these slides will now be available on our Chamber's website under our coronavirus unit, along with all the previous seminars that we've done, and the recording will be available. I can't promise that Tara's audio will be any better, I'm afraid, but hopefully it will. So thank you very much for joining us, that's it for now. Thank you very much. Have a very good rest of the day and enjoy the sunshine.